We have built our firm around one idea: to lead our clients from where they are to where they want to be. But the ability to deliver the leadership and service our clients deserve doesn't happen by chance. It's a product of who we are. We are engaged, diverse, and innovative thinkers who go above and beyond what is expected because we know our efforts will carry us to achievements others never thought possible. We are unafraid to take the necessary risks that lead to new successes. We embrace change because we know sound principles will guide us through new opportunities. We are committed to empowering our people, our clients, and our communities to become every part of what they aspire to be. We are persistent on our journey forward. It is our openness to collaboration, our desire to achieve better, our character, our vision, and most of all, our people that make us who we are. That's the HB difference. We are Husch Blackwell.
Hello, everyone. I'm Ann Mayette, a Senior Associate in Husch Blackwell's Labor and Employment Practice. Before we begin today, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all the questions during the webcast today, but if a fuller answer is needed or if we run out of time, it will be answered later via email. A PDF of the presentation is available in the resources folder. This program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow along with a recording of the webcast for watching and sharing. Towards the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That is all for the housekeeping items. Let's get started with our program. We'll be talking with you today about the Illinois Workplace Transparency Act, which became effective January 1, 2020. This webinar will outline all the new requirements employers must navigate to comply with the Act. Joining me today is Sarah Quinn. Sarah is an experienced labor and employment attorney who has litigated Fair Labor Standards Act collective actions, state wage and hour class actions, non-compete claims, employment classification claims in state and federal courts. And with that, let's get started. So we're talking to you today about the Illinois Workplace Transparency Act, and the Act was put into place as a result of a kind of changing political landscape here in Illinois. In January 2019, J.B. Pritzker was sworn in as Illinois' 43rd governor. This represented a change from Republican to Democrat leadership in Illinois. Even in his inaugural speech, Governor Pritzker emphasized that he was going to be concentrating on employment issues in the state of Illinois. He emphasized his commitment to enforcing laws that protect workers' wages and workers' rights. He discussed his desire for a $15 minimum wage and an Illinois Department of Labor that will effectively work to enforce the laws that are protecting workers. So Governor Pritzker, he worked very quickly to make immediate changes to employment laws once he was in office. For example, on January 15, 2019, just 15 short days after he was, and on his first full day in office, he signed an executive order which, among other things, directed the Department of Labor to review pending cases under the Wage Payment and Collection Act, the Minimum Wage Law, and the Day and Temporary Service Act to identify cases of wage theft and day labor exploitation and refer appropriate cases to the Attorney General. Perhaps the most significant change to Illinois employment laws thus far is the enactment of the Illinois Workplace Transparency Act, which we're talking about today. This was something that Governor Pritzker really wanted and worked hard to get into effect very quickly. The Workplace Transparency Act went into effect on January 1st, 2020, and it made significant changes to the Illinois Human Rights Act, which is the state's discrimination and harassment law, the Victims' Economic Security and Safety Act and the Hotel and Casino and Employee Safety Act. In addition to making those changes with respect to the Workplace Transparency Act, Governor Pritzker made and signed into law additional changes to many of Illinois' employment laws. Significant amendments have been made to each of the laws listed here. While we won't go over those changes in this webinar, if you have any questions regarding the changes to these acts, please feel free to reach out to us after this webinar. And also, as a reminder, do not forget that the minimum wage in Illinois increased to $10 per hour on July 1st as a part of the changes to the minimum wage law in Illinois. And with that, I'm going to turn it over to Sarah, and she is going to start outlining what's required under the Illinois Workplace Transparency Act.
Thank you, Anne. Hello, afternoon, everyone. My name is Sarah Quinn, and let's dig into the Illinois Workplace Transparency Act. The Illinois Workplace Transparency Act applies to employers, and that term is defined in the Illinois Human Rights Act. From January 1st until July 1st of 2020, the definition of employers applied to those who have 15 or more employees within Illinois during 20 or more calendar weeks in a calendar year. However, on July 1st, 2020, amendments to the Illinois Human Rights Act went into effect that extend the Workplace Transparency Act to any employer with one or more employees within Illinois during a 20 or more calendar weeks in a calendar year. I'll pause for a second to note that this applies even to employers outside of Illinois, but who have employees within the state of Illinois. The Workplace Transparency Act protections apply to a broad group of employees. This includes full-time and part-time employees, apprentices, unpaid interns, and under the Illinois Human Rights Act, individuals categorized as non-employees. Here, that means consultants and contractors who perform work for the employer pursuant to a contract. However, the Workplace Transparency Act does not apply to employees that are subject to collective bargaining agreements. Employers may not, under the Illinois Workplace Transparency Act, prevent employees or prospective employees from making truthful statements or disclosures about alleged unlawful employment activities or about criminal activity. Likewise, under this law, employers may not require employees to waive, arbitrate, or diminish any currently existing or future claim related to unlawful employment practices. However, the Workplace Transparency Act does not prohibit employers and employees from bargaining for certain waivers in their employment or separation agreements if such agreements are in writing and contain various disclaimers. Here, the prohibition focuses, and we'll be covering a lot of attention to, what it means as a unilateral agreement or a unilateral provision within an agreement. It is allowed, however, to mutually bargain for such provisions, and we will discuss those requirements for a mutually bargained for provision in a moment. Here, the Workplace Transparency Act defines an unlawful employment practice as any form of unlawful discrimination, harassment, or retaliation that is actionable under the following laws. Those are Article 2 of Illinois Human Rights Act, Article 7 of the Civil Rights Act of 1964, or any other state or federal rule or law that is enforced by the Illinois Department of Human Rights or the Equal Employment Opportunity Commission. Now, these changes are broad and are employee-friendly, but it's important to note that this law could have been much worse for employers. There were several items included in the original version of this bill that didn't make it into the final legislation. It's important we discuss these to know that they were contemplated by the legislature and know that they could be on the horizon in the future. First, the original Workplace Transparency Act would have prohibited unilateral non-disparagement agreements, but the prohibition was left out of the final version. Secondly, the original version would have required employers to report all settlements of sexual harassment and other discrimination claims on an annual basis. That is in addition to the requirement that Anne will talk about in a moment to report adverse judgments and administrative rulings. The final version of the bill only requires disclosure of settlements to the IDHR when it is requested during an investigation of a charge of discrimination filed before them. And finally, the original version of the changes to the IDHR would have included vendors and subcontractors in its definition of those who are protected from sexual harassment and other discrimination. It's important to note that these were contemplated again, but did not make it into the final bill. Under the Workplace Transparency Act, employment agreements cannot impose three types of non-negotiable unilateral conditions. The Workplace Transparency Act defines unilateral conditions of employment or continued employment as any contract, agreement, clause, covenant, or waiver where an employer requires that employee or prospective employee to accept as a non-negotiable material term in order to obtain or retain employment. These three types of conditions that cannot be included unilaterally into employment agreements are those that prevent prospective or current employers from making truthful statements about alleged unlawful discrimination, harassment, or retaliation, those that require prospective or current employees to arbitrate claims relating to alleged unlawful discrimination, harassment, or retaliation, or third, that require them to waive or diminish existing or future claims, rights, or benefits relating to such unlawful discrimination, harassment, or retaliation. But employers, this does not mean that all hope to ensure confidentiality or arbitrate claims is lost. There are exceptions to these requirements. Provisions relating to confidentiality and arbitration may be allowed if they are part of a mutual agreement between that employer and employee. There are several requirements to prove that there was a mutual agreement. First, the agreement must be written. Second, it must demonstrate that there was an actual, knowing, and bargained for consideration from both parties. And third, in the contract or agreement, it must acknowledge the right of the current or prospective employee to, 1, report any good faith allegation of unlawful employment practices to an appropriate federal, state, or local government agency enforcing discrimination laws. Report 2, report any good faith allegation of criminal conduct to similar appropriate government agencies. 3, participate in a proceeding with any appropriate federal, state, or local government agency enforcing discrimination laws. 4, that they may make truthful statements or disclosures required by law, regulation, or legal process. And 5, that they may request or receive confidential legal advice. These mutual conditions of employment or continued employment means that in any contract, agreement, clause, covenant, waiver that's negotiated between an employer and an employee or prospective employee must be done in good faith and for consideration in order to obtain or retain employment. Here's an important thing to note if you are an employer. if an employer fails to comply with these requirements for mutual agreements, there is a rebuttable presumption that the condition imposed was unilateral, and unilateral conditions are void for public policy reasons and severable from an otherwise valid and enforceable agreement. So any failure to comply with these requirements will create a rebuttable presumption that it was unilateral and therefore in violation of the Workplace Transparency Act. Let's talk specifically about arbitration and confidentiality provisions for a moment. First, arbitration agreement. The Workplace Transparency Act prohibits mandatory arbitration provisions for claims involving unlawful employment practices. So, in order for an employment agreement to provide for arbitration as the sole method of dispute resolution, the same requirements for employment agreements must be met. Remember, this means the provision must be mutual, in writing, and reflect bargain for consideration, and include those same written acknowledgments of rights as outlined in the last slide. Remember, mutual condition of employment or continued employment means that any contract, agreement, clause, covenant, waiver must be negotiated between the employer and the employee or prospective employee in good faith and for consideration in order to obtain or retain employment. Now, many mandatory arbitration provisions are traditionally unilateral and are non-negotiable in the employment context. So here, Illinois has taken a big step to essentially prohibit mandatory take-it-or-leave-it arbitration provisions involving unlawful employment practices. It's important to note that this provision appears to be in direct conflict with the Federal Arbitration Act. Similar laws to the Workplace Transparency Act in other jurisdictions, such as New York, have been found to contradict the Federal Arbitration Act, which requires enforcement of arbitration agreements involving interstate commerce. Until the Workplace Transparency Act is challenged in Illinois courts, it's questionable how a court would enforce this provision. Now to confidentiality provisions. The Workplace Transparency Act, again, prohibits an employment agreement or contract provision that is unilateral and has the purpose or effect of preventing employees or applicants from making truthful statements or disclosures regarding unlawful employment practices. Such provisions are void as a matter of public policy, and if included as part of a broader confidentiality requirement, risks voiding the entire confidentiality obligation. Again, the key term here is unilateral, as the Workplace Transparency Act does not permit employers to bargain with new hires or employees for confidentiality provisions that are prohibited as unilateral terms of employment. Specifically, a confidentiality provision prohibiting statements regarding unlawful employment practices is permissible if it is mutual, in writing, and demonstrates actual knowing or bargain for consideration, and includes the written acknowledgments that we discussed in the previous slide. Again, those are reporting good faith allegations of unlawful employment practices to government agencies, reporting good faith allegations of criminal conduct to the same, participating in a proceeding for a government agency, making truthful statements and disclosures required by law, or receiving confidential legal advice. Important, no confidentiality agreement can ever prohibit reporting unlawful employment practices to government agencies or participating in proceedings related to the same. Now, this leaves Illinois employers or employers with Illinois employees with two options when navigating confidentiality provisions. First, the policy should be revised to make clear that nothing in the confidentiality obligation requires the individual to refrain from making truthful statements or disclosures regarding unlawful employment practices or criminal conduct. Or 2, draft an individual specific provision that reflects separate bargain for consideration and includes that required language we mentioned before. The Workplace Transparency Act allows employers to require confidentiality from employees or third parties who fall into one of the following buckets. First, if they receive or investigate complaints of unlawful discrimination, harassment, or retaliation from others, or have access to confidential personnel information, such as your human resources team. 2, if they participate in an ongoing investigation into unlawful discrimination, harassment, or retaliation during the pendency of or after an investigation. This includes complainant, witnesses, and accused that participate in an investigation. Third, those who receive attorney work product or attorney-client privilege communication as part of any dispute, controversy, or legal claim involving unlawful discrimination. 4, if it is required by law or subject to a legal or evidentiary privilege. Or 5, that they are engaged or hired by the employee to investigate complaints of unlawful discrimination, harassment, or retaliation, such as third-party vendors that might be contracted to handle a large load of internal investigations. Again, those five buckets are not prohibited from requiring confidentiality under the Workplace Transparency Act, and employers are free to impose confidentiality restrictions on those employees or third parties. So, under the Workplace Transparency Act, a settlement and termination agreement can require confidentiality relating to alleged unlawful discrimination, harassment, or retaliation, but only if the following requirements are met. First, the agreement states that confidentiality is the employee's preference and it is beneficial to both parties. 2, that the employer notifies the employee in writing of that employee's rights to have an attorney or representative of the employee's choice review the agreement before it is executed. 3, it states that there is a valid bargain for consideration in exchange for such confidentiality. 4, the settlement or termination agreement does not waive claims of unlawful discrimination, harassment, or retaliation that arise after the settlement or termination agreement is executed. And the employee must be given 21 days to consider the written agreement. However, the employee may execute the agreement earlier and waive the remaining time to consider it. And finally, the employee has 7 calendar days after executing the agreement to revoke it, and the agreement is not enforceable until that revocation period has expired. Employers cannot unilaterally include any clause that prohibits the employee from making truthful statements or disclosures regarding unlawful discrimination, harassment, or retaliation. Other important things to note. While not a part of the Workplace Transparency Act, in a separate bill, which was approved by Governor Pritzker on August 20th, 2019, the definition of employer was expanded to include any entity that employs one or more persons, and this new definition took effect on July 1. The Illinois Human Rights Act also now prohibits harassment, including sexual harassment, by an employer against non-employees. So this means harassment against contractors, consultants, or anyone else who directly performs services for the employer pursuant to a contract with that employer. The amendments also expand the definition of unlawful discrimination to now include discrimination against a person because his or her actual or perceived protected class. Remember, in Illinois, this includes race, color, religion, national origin, ancestry, age, sex, marital status, order of protection status, disability, military status, sexual orientation, pregnancy, or unfavorable discharge from the military. Previously, the concept of perceived only applied to discrimination in the context of disability or sexual orientation context. This amendment now applies it to all protected class statuses. Harassment has also been expanded to include unwelcome conduct on the basis of a person's actual or perceived protected class status. This expands to include having the purpose or effect of substantially interfering with the individual's work performance or creating an intimidating, hostile, or offensive working environment. Of course, we must note that working environment is not limited to a physical location, as employees may be assigned to perform their duties outside the office. Lastly, employers may be held liable for its employees' harassment of non-employees. That means if its employees harass individuals such as independent contractors who perform services for the employer, and the employer was aware of the conduct and failed to take reasonable corrective measures, the employer can face liability for such conduct. This addition now explicitly makes employers also responsible for harassment or sexual harassment of non-employees by individuals who are non-managerial or non-supervisory employees. You should revise any anti-harassment policies to specifically address harassment of third parties and include a complaint mechanism for third parties to raise discrimination or harassment complaints. Now I'll turn it back to Anne to tell you about some of the reporting and training requirements under these changes.
Thank you, Sarah. So as Sarah had previously gone through, there were a significant amount of changes to the Illinois Human Rights Act pursuant to the Workplace Transparency Act with respect to settlement agreements and employment agreements. Not only did the Workplace Transparency Act make those changes, the Act has now included an affirmative obligation on the part of employers to annually disclose to the Illinois Department of Human Rights any adverse judgment or administrative ruling. It now requires annual sexual harassment training for employees and additional sexual harassment prevention training for restaurants and bars. And we will go through those in detail on these next few slides. With respect to the annual reporting to the Illinois Department of Human Rights, under the new law, beginning on July 1st, 2020, and each July 1st thereafter, employers will be required to disclose on an annual basis to the Illinois Department of Human Rights any adverse judgments or administrative rulings against them in the preceding calendar year. With respect to who they are including in these reporting requirements, they are defining employers as any person employing one or more employees in Illinois, a labor organization, so for example, a union, or a state government, municipal corporations, or other governmental units or agencies within the state of Illinois. And so you're asking yourself, so what exactly do they define an adverse judgment or administrative ruling as? The Illinois Department of Human Rights is defining an adverse judgment or administrative ruling as any final and non-appealable adverse judgment or final and non-appealable administrative ruling entered in favor of an employee or a non-employee to whom the employer owes a duty under the Illinois Human Rights Act, and then against the employer during the preceding year in which there was a finding of sexual harassment or unlawful discrimination brought under the Illinois Human Rights Act, Title VII, or any other federal, state, or local law prohibiting sexual harassment or unlawful discrimination. So examples of these would be a final order against an employer issued by a state of Illinois tribunal, such as the Illinois Human Rights Commission, a local unit of government, such as the Cook County Commission on Human Rights, or the Chicago Commission on Human Relations, or an Illinois Circuit Court. This also would include a final judgment entered by a federal court in a matter arising under Title VII, the Age Discrimination in Employment Act, or the Americans with Disabilities Act. These would also qualify once the judgment is no longer appealable. Decisions in unemployment insurance proceedings are not considered adverse judgments or administrative rulings, and those do not need to be included. As Sarah had mentioned earlier, the employer may be required to disclose information on settlements of any sexual harassment or unlawful discrimination claims, but only if the Illinois Department of Human Rights is investigating a charge filed under the Illinois Human Rights Act and makes the request. With request to settlement, the Illinois Department of Human Rights is defining that as any written commitment or written agreement, including agreed judgment, stipulation, decree, agreement to settle, assurance of discontinuance, or otherwise between an employee or a non-employee who the employer owes a duty under the Act, and an employer under which the employer directly or indirectly provides individual compensation or other consideration due to an allegation that the individual has been a victim of sexual harassment or unlawful discrimination under the Act. So the key takeaway there is that employers are going to need to start compiling this information and keeping track throughout the year of any settlements, any adverse judgments, or rulings. An important thing to note with respect to the disclosure requirements, an employer may not disclose the name of a victim of an act of alleged sexual harassment or unlawful discrimination in any disclosures required under this new provision. And so you're probably asking yourself at this point, okay, why do they want this information? What are they going to do with this? Is this confidential? The Illinois Department of Human Rights is going to take this information reported by employers and publish an annual report that aggregates the data, but it will not publicly identify the employers. So it's important to know that they're going to publish the annual report, but that no individual employer data is going to be available to the public. The report's going to include the number of adverse judgments or administrative rulings filed during the preceding calendar year, based on each of the protected classes that are identified by the Illinois Human Rights Act. And then the report is going to be filed with the Illinois General Assembly and made available to the public by December 31st of each reporting year. I think another important fact to point out to everyone is that any of this data submitted by an employer to comply with this provision of the Act is confidential and is exempt from the Freedom of Information Act. So if there is a FOIA request that happens to request this information, it is not allowed to be disclosed. And lastly, another very important factor with respect to this reporting requirement is the failure to report will result in penalties. So there is a provision in the Act that states that if an employer fails to make any disclosures required under the section, the department is going to issue a notice to show cause that will give the employer 30 days to disclose the required information. If the employer does not make the required disclosures within 30 days, the department shall petition the Illinois Human Rights Commission for an entry of order imposing a civil penalty against the employer. The civil penalties for failure to report are based on the number of employees, and the penalty will be higher for larger penalties or for larger employers. And the penalties will also be increased based on the number of offenses. So, for example, for employers with fewer than 4 employees, the maximum penalty for the first offense is $500, a second offense is $1,000, and a third and subsequent offenses are $3,000. For employers with 4 or more employees, the maximum penalty for the first offense is $1,000, a second offense is $3,000, and a third and subsequent offenses are $5,000. So now that you know you have to report, the big question is, when do you have to report? The reporting period for 2019 began on July 1st, 2020. I say that, and I make a point to say that it begins on July 1st, 2020, because we just recently got all of this information from the Illinois Department of Human Rights. They've just recently issued all of this guidance so that we know when the reporting time periods are. So in 2020, the disclosures will be due by October 31st, 2020. So for any adverse judgments or administrative rulings that your company incurred in calendar year 2019, you have until October 31st, 2020 to report those adverse judgments or rulings to the Illinois Department of Human Rights. For subsequent calendar years, the deadline is going to be July 1st. So for any judgments or rulings that occur from January 1st, 2020 to December 31st, 2020, the actual filing deadline will be on July 1st, 2021. So now that we know that we have to report and when we have to report, the question you're probably all thinking now is, what do we have to report? So what is an adverse judgment or administrative ruling? So what that means is employers will have to determine the total number of adverse judgments or administrative rulings in the preceding year, whether any equitable relief was ordered against the employer in the adverse judgment or administrative ruling, how many adverse judgments or administrative rulings, and then you will have to break them down by the following categories: sexual harassment, discrimination or harassment on the basis of sex, race, color, or national origin, religion, age, disability, military status or unfavorable discharge from military status, sexual orientation or gender identity, and discrimination or harassment on the basis of any other characteristic protected by the Act. So the key takeaway here is that when you're compiling information for reporting purposes, you should make sure to determine which category it fills in, which protected characteristic it would fall under, whether there was equitable relief, and how many of each category. So I think the next big question everyone has on their minds is, okay, now that we know we have to report, when we have to report, what we have to report, well, how do we report it? So employers can file their disclosure report with the Illinois Department of Human Rights by downloading the form IDHR 2-108 from the website listed here. It's www.illinois.gov/DHR, and then filing it with the Illinois Department of Human Rights. I will tell you, the form is not available yet. The Illinois Department of Human Rights has stated it will be available for download on July 20th. So hopefully coming up here soon, that form will be available for download. And then I think the biggest takeaway here on reporting, the biggest question I've received on this is, what if you don't have any adverse judgments or administrative rulings? What do you do then? The Illinois Department of Human Rights has come out and stated that only employers who have had one or more adverse judgments or administrative rulings against them in a given calendar year are required to disclose the required information. So if you don't have any administrative judgments or rulings against you, there is not an obligation to report. Oh, and I neglected to mention here, and just so you can see here on the slide, you can also report by emailing the form to the email address listed here, which is idhr.webmail@illinois.gov. As Sarah had discussed briefly earlier, you will not affirmatively have to disclose settlements. If the department is investigating a charge filed pursuant to the Illinois Human Rights Act, the department may request that the employer responding to the charge submit the total number of settlements entered into during the preceding 5 years. And that's important. It's the preceding 5 years. They have the discretion to ask for less, but they can ask for up to 5 years worth of settlement. And they can request any settlements that have been entered into that relate to any alleged acts of sexual harassment or unlawful discrimination that occurred in the workplace of the employer or involved the behavior of an employee of the employer or a corporate executive of the employer without regard to whether that behavior occurred in the workplace of the employer. So that's important and very important to point out is they've provided that you need to disclose settlements that are entered into on the basis of behavior that may not have occurred in the workplace. In the same manner in which adverse judgments and rulings are reported, the total number of settlements entered into during the requested period should be reported, and it should be broken down into the categories that I listed before: sexual harassment, discrimination on the basis of sex, race, color, national origin, religion, age, disability, military status or unfavorable discharge from military status, sexual orientation or gender identity, and any other characteristic that's protected under the Illinois Human Rights Act. Important to note here, because the only time that the Illinois Department of Human Rights can request information related to settlement agreements is when they are actively investigating a charge of discrimination that's been filed. The department is not allowed to rely on the existence of any settlement agreement to support a finding of substantial evidence under the Act. They're not allowed to use the fact that the employer may have previously entered into a settlement agreement related to a claim of sexual harassment or discrimination to support any sort of finding when investigating the current charge. The next obligation that we're going to discuss that was imposed pursuant to the Illinois Workplace Transparency Act is the requirement for annual sexual harassment training. So besides reporting, now there is this training requirement. So as of January 1st, 2020, employers are required to train each and every employee each calendar year. So every employer with one or more employees working in Illinois, and that's key here, working in Illinois, will need to provide sexual harassment prevention training on an annual basis. The law that the Workplace Transparency Act directed the Illinois Department of Human Rights to establish a model training program that would be made available to employers and to the public online at no cost. That has been made available, that is available on their website. So employers need to provide their employees with this sexual harassment prevention training by December 31st, 2020, and then annually thereafter. For individual employees, fulfilling the annual training requirement is based on the calendar year. The IDHR has stated that employers should provide the training to new staff as soon as possible after hire or by December 31st, 2020 in this first year. They are encouraging employers to train employees as soon as possible because employers are liable for the sexual harassment conduct of new employees right upon their hire. So on their first date of hire, they become liable. It's important to note here, training on an annual basis for every employee is a significant task to be undertaken and requires a significant amount of time and effort to be put into place by employers and employees. If an employer does decide to require their employees to take the training outside of their regular work hours, for example, if you develop a training program that can be taken on personal phones or laptops before the employee starts a shift, they must be paid for their time. So anytime the employee is taking the training, that is compensable time. It's also important to note that the training needs to be available in a way that is accessible to all employees of the employer. If the employees have a disability or speak a language other than English, employers are required to train employees in a manner that's accessible to them. And I also want to note here, and I'll go over it a little bit more detail, the amendments do impose additional requirements besides those I've just talked about for restaurants and bars. To give you a definition here too, they are defining a restaurant as including coffee shops, cafeterias, and catering facilities. So the training requirement says that every employer that has one or more employee must train their employees. So who are they defining as employees? The Act defines it as all employees regardless of their status. That includes short-term, part-time, or interns. They all have to be trained. Employers are not required to train independent contractors. However, the Illinois Department of Human Rights is strongly advising that independent contractors receive the training if they're working on site at the employer's workplace or interact with the employer's staff. I think this next point is one that everybody is going to want to write down. We're talking about the Illinois Human Rights Act and training for Illinois employees, but the Illinois Department of Human Rights has taken the position that it's not just any employee who works or will work in Illinois that must be trained. They are saying that if an employee is based elsewhere, but regularly interacts with other employees in Illinois, even if they're not physically present in Illinois, they should be trained. So for example, if Supervisor A works for ABC Company in another state, for example, Indiana, California, Florida, and supervises employees of ABC Company who work in the state of Illinois, Supervisor A should receive the sexual harassment prevention training compliant with the Illinois Human Rights Act, even though Supervisor A is employed in another state. Another example, employee B works for ABC Company in another state and will be working on a temporary basis with employees of ABC in Illinois. Employee B should receive sexual harassment prevention training compliant with the Illinois Human Rights Act, even though employee B's home employer is in another state. This is a very important point, especially with how companies operate now with the significant uptick in remote workers, in remote working due to COVID-19, having employees working in different states and managing or supervising employees in Illinois. We need to make sure that every employee receives this training that is compliant with the Illinois Human Rights Act. I know many of the employers on this call do have employees that may work multiple jobs. And so you're thinking, well, do we need to train them if they've taken the training at another workplace? The answer to that is no. If employees have multiple jobs, they do not need to take the training at each workplace where they work over the course of a year. Employers can request that the employees provide proof of completion of the sexual harassment prevention training at another employee's. And you should, when doing that, request the certificate from the other employer who provided the training so that you can have proof. It's very important that employees are not responsible for confirming that their previous training complies with the training requirements in the Illinois Human Rights Act. If there's a question of compliance, employers should just require that the employee be trained again. So now that we know who must be trained, what do they have to be trained on? What are the requirements of this sexual harassment training? Like I said before, the Illinois Department of Human Rights has developed a model sexual harassment prevention training, which is available on their website. However, they have stated that employers may develop their own training as long as it complies with the requirements of the Act. And those include an explanation of sexual harassment consistent with the Illinois Human Rights Act, examples of conduct that constitutes unlawful sexual harassment, a summary of relevant federal and state statutory provisions concerning sexual harassment, including remedies available to the victims of sexual harassment, and a summary of responsibilities of employers in the prevention, investigation, and corrective measures of sexual harassment. Employers may use a third-party vendor organization, have existing staff deliver the training, or create and deliver their own training that complies with the minimum standards that I just stated. If you are having a third party do the training, you need to ensure that it meet or exceeds the minimum standards that are required. I'd like to let everybody know that at this time we have developed a model training that's compliant with the Act. If you would like to discuss the different options available for customizing and delivering the training, please feel free to reach out to us at the end of the webinar, and we can discuss the options that are available for your organization. And as I stated a little bit, and I alluded to before, there are other requirements for restaurants and bars. Those include specific conduct, activities, or videos related to the restaurant or bar industry. So you should include in the training specific conduct or activities. There should be an explanation of manager liability and responsibility under the law, and English and Spanish language options. And those are the specific additional requirements for restaurants and bars. In addition, restaurants and bars must develop a sexual harassment prevention policy and provide a copy of it to their employees. I know most employers already do this, but it is an affirmative obligation with respect to restaurants and bars now in Illinois. If you do fail to comply with conducting the annual sexual harassment training, there are civil penalties. These can range from $500 to $5,000 depending on the employer size and the number of violations. Along with giving the training, you will also need to keep records of who has completed the training. So employers are required to keep record of all the trainings. The records must be made available for the Illinois Department of Human Rights for inspection upon request. These records can be a certificate, a signed employee acknowledgement, or a course signing sheet, and you are allowed to keep these records in paper or electronic form. And with that, those are all the requirements for the reporting and training under the Illinois Workplace Transparency Act. I'm going to turn it back over to Sarah, who is going to give you an outline of the changes to VESA and the Hotel and Casino Employees Act.
Thank you, Anne. I have two quick additional changes that you should be aware of. The first having to do with the Victims Economic Security and Safety Act, otherwise known as VESA, which allows for employees to have unpaid leave as it relates to sexual violence or household members that are victims of such violence. This law was amended to include the victims of gender violence, and gender violence is defined as violence or aggression that is illegal under Illinois state law and committed in part on the basis of a person's actual or perceived sex or gender, whether or not criminal charges were ultimately brought. One item to note, the original law would have expanded this VESA definition to include sexual harassment. So an employee who was a victim of sexual harassment at your workplace would have been entitled to leave afterward. However, the legislature passed only the version that included gender violence. So again, something to be aware of that might be on the horizon for additional expansion. But right now, it's limited to the definition as we explained. Lastly, it's important to note that there has been change in the Hotel and Casino Employee Safety Act. This law requires that hotels and casinos with employees who may work alone in a guest room or restroom or on a casino floor has a capability to notify someone for help if they have a safety concern. So this could be some sort of mechanism that they could wear on their bodies to call security or notify someone for help if they get in a compromising situation. So that brings us to the end of our presentation today, but most importantly, how can your organization ensure compliance with these regulations that we've outlined? Well, first and foremost, you'll want to update any confidentiality and separation agreements that you use. I noticed that a question came in about whether it applies to onboarding documents as well as separation documents, and the answer is yes, absolutely. If any of your employees sign agreements at the onboarding stage that includes confidentiality requirements or arbitration agreements, please update those as well as a standard termination or separation agreement. You'll want to revise your anti-harassment policies to reflect the changes we talked about today, specifically including harassment on third-party contractors or consultants. You'll want to start planning and delivering annual anti-harassment training. And finally, put on your calendars to remain aware of that October 31, 2020 date to submit the mandatory disclosures to the Illinois Department of Human Rights. At this point, we have a few minutes left before the end of the hour. We will open it up for the questions that we've had submitted to us through the portal. I'll take a first one here. I would receive a question that says, does the law distinguish between unpaid interns and unpaid volunteers? I understand that a lot of your companies might have individuals on site that are there just to volunteer. And the answer to that is the law does not specifically distinguish between interns and volunteers. But what the Illinois Human Rights Act does is it defines what an unpaid intern is. And they define that individual as someone who is performing work that supplements training given in the educational environment that may enhance the employability of the intern. If that does not apply to your volunteers, meaning it's not supplementing an educational environment, then it would be my advice that it is not inclusive of volunteers who don't fall into that bucket. One last point I want to make clear about the way the law applies to unpaid interns is it specifically applies to the section of the law dealing with sexual harassment. This means that if an unpaid intern engages in sexual harassment of either employees or non-employees, such as those independent contractors, liability can be attributed to the employer if the employer had reason to know and failed to adequately respond. And I'll turn it over to you to answer a question on reporting and training, if you'd like.
Yes, absolutely. I do want to make clear we did get one question regarding whether reporting is required for adverse actions outside of Illinois, and the answer to that is yes. So it is not just actions that are decided in any sort of forum within Illinois. You need to keep track and report a finding of sexual harassment or unlawful discrimination under Title VII that it has occurred in any of the states, any other jurisdiction. So please keep that in mind. That's what makes this a very significant undertaking for employers, and keep in mind that you should get started on compiling that information right now.
So I'll jump in with another question we received, and it is, if new employment or continued employment are not sufficient consideration for arbitration and confidentiality provisions, Is there any guidance on what would constitute sufficient consideration, such as monetary, and if so, how much? The answer to that question is we don't have guidance from the court about what adequate consideration would be. So I would urge employers to have an additional piece of consideration. So it is not enough to simply say your employment at the salary that we negotiated is consideration. Remember, that triggers that unilateral condition of employment language that we talked a lot about during the presentation. You will need something in addition to that, but there isn't a lot of guidance around how much. So that really is a business decision. That's something you'll want to talk about with your leadership.
And with that, I think we've hit our time period. We've hit the hour. Sarah, why don't you go ahead and wrap us up?
Certainly. So thank you so much for joining us today. We really hope that the information was helpful to you and to your organization. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be mailed to you tomorrow, along with a recording of the webcast for watching and sharing. Please be sure to complete our short survey. We use your feedback to plan future programs and that are applicable to your business needs. We have received a lot of your questions, so we will get through these as best we can and address the questions to the individuals directly, and this will conclude our webinar. Thank you so much for joining us.
Thank you.